Governor A was given the amount of 10 million by the Department of Agriculture for the purpose of buying seedlings to be distributed to the farmers. Supposedly intending to modernize the farming industry in his province, Governor A bought farm equipment through a direct purchase from XY Enterprise, owned by his compadre B, the alleged exclusive distributor of the said equipment. Upon inquiry, the ombudsman discovered that B has a pending patent application of the said farm equipment. Moreover, the equipment purchased turned out to be overpriced. What crimes if any, were committed by Governor A? 2016. Governor A committed the crimes of 1. Technical malversation. 2. Violation of Section 3, letter E and G of the Republic Act of 3019. Governor A committed the crime of illegal use of public funds or property punishable under Article 220 of the Revised Penal Code. This offense is also known as technical malversation. The crime has 3 elements: that the offender is an accountable public officer, B, that he applies public funds or property under his administration to some public use, and C, that the public use for which such funds or property had been applied is different from the purpose for which they were originally appropriated by law or ordinance. Isidro versus People. The amount of 10 million granted by the Department of Agriculture to Governor A, an accountable public officer, is specifically appropriated for the purpose of buying seedlings to be distributed to the farmers. Instead, Governor A applied the amount to acquire modern farm equipment through direct purchase from XY Enterprise, owned by his compadre. The law punishes the act of diverting public funds earmarked by law or ordinance for a specific public purpose to another public purpose, hence the liability for technical malversation. Governor A can also be held liable for violation of Section 3 of Republic Act No. 3019 or the Anti-Graft and Corrupt Practices Act, which has the following elements. 1. The accused is a public officer discharging administrative, judicial, or official functions. 2. He must have acted with manifest partiality, evident bad faith or gross inexcusable negligence. And 3. His action caused any undue injury to any party, including the government, or gave any private party unwarranted benefits, advantage, or preference in the discharge of his functions. The facts show that the first element is present. The second element is likewise present because through manifest partiality in favoring his compadre, Governor A did not hold a public bidding and directly purchased the farm equipment from the latter. With respect to the third element, Governor A's action caused undue injury to the government as well as the farmer who were deprived of the seedlings. His acts likewise gave his compadre private party the unwarranted benefit, advantage, or preference to the exclusion of other interested suppliers. The act committed by the governor is also in violation of Section 3, letter G of RA number 3019 for entering a contract on behalf of the government, which is manifestly and grossly disadvantageous to the same. Malo, a clerk of court of trial court, promised the accused in a drug case pending before the court that he would convince the judge to acquit him for a consideration of 5 million. The accused agreed and delivered the money through his lawyer to the clerk of court. The judge, not knowing of the deal, proceeded to rule on the evidence and convicted the accused 2014. Malo was charged with violation of Section 3, letter B, Republic Act number 3019, which prohibits a public officer from directly or indirectly requesting or receiving any gift, present, share, personage, or benefit wherein the public officer in his official capacity has to intervene under the law. He was later charged also with indirect bribery under the Revised Penal Code. Malo claims he can no longer be charged under the Revised Penal Code for the same act under RA 3019. Is he correct? No. One may be charged with violation of RA 3019 in addition to felony under the RPC for the same intellectual act, either concurrently or subsequent to being charged with a felony under the RPC. This is very clear from Section 3 of RA 3019. Also, RA 3019 is a special law. The elements of the crime is not the same as those punished under the RPC. Malo was charged with estafa under Article 315 because he misrepresented that he had influence when he actually had none. Is the charge correct? Yes, estafa is committed by any person who shall ask for money from another for the alleged purpose of bribing a government employee when in truth the offender intended to convert the money to his own personal use and benefit. Roger and Jesse, municipal mayor and treasurer, respectively, of San Rafael Leyte, caused the disbursement of public funds allocated for their local development programs for 2008. Records show that the amount of 2 million was purportedly used as financial assistance for a rice production livelihood project. Upon investigation, however, it was found that Roger and Jesse falsified disbursement vouchers, supporting documents in order to make it appear that qualified recipients, who in fact are non-existent individuals, received the money. Roger and Jesse are charged with violation of Section 3, letter E of R8 1319 for causing undue injury to the government. Discuss the propriety of the charge filed against Roger and Jesse. They should be charged of violation of Section 3, letter E of 1319 for the breach of public trust and undue injury caused to the government. The violation is a crime malum prohibitum. Proserpina, an assistant public high school principal, acted to facilitate the release of salary differentials and election duty per diem of classroom teachers while the agreement that they would reimburse her for her expenses. Did Proserpina commit a crime? 2010. Yes, Proserpina committed violation of Section 3B of Republic Act 1319, which considers as corrupt practice. Directly or indirectly requesting or receiving any gift, present, share, personage, or benefit for himself or for any other person in connection with any contract or transaction between government and any other party, wherein the public officer, in his official capacity, has to intervene under the law. Being the assistant public high school teacher or principal, it is her duty to intervene in the release of salary differentials and per diem of classroom teachers under her. Her act of doing so, made a request for a share of benefit therefor, constitute graft or corrupt practice under Section 3B, Republic 1319. Considering that the acts prohibited or punished under this law are mala prohibita and thus punishable thereunder, whether done with criminal intent or not. Alternative answer, in the case of Javarata versus Sandigan Bayan, which has identical sets of facts as the present case, the Supreme Court ruled that there is no law which invests an assistant principal with the power to intervene in the payment of the salary differentials of classroom teachers, or anyone for that matter. Accordingly, since in his official capacity as the assistant principal he is not required by law to intervene in the payment of the salary differentials, the assistant principal cannot be said to have violated Section 3, letter B of R8 1319, although he exerted effort to facilitate the payment of the salary differentials. City Engineer A is the city engineer and the chairman of the Bids and Awards Committee (BAC) of the City of Kawawa. In 2009, the City of Kawawa, through an ordinance, allotted the amount of 100 million for the construction of a road leading to the poblacion. City Engineer A instead diverted the construction of the road leading to his farm. Investigation further showed that he accepted money in the amount of 10 million each from 3 contending bidders who eventually lost in the bidding. Audit report likewise showed that service vehicles valued at 2 million could not be accounted for. All the reports showed that these were lent to Engineer A's authorized drivers, but the same were never returned. Further, there were funds under City Engineer A's custody amounting to 10 million for which were found to be missing and could not be accounted for. In another project, he was an instrument awarding a contract for the construction of a city school building, costing 10 million to a close relative, although the lowest bid was 8 million. Investigating also revealed that City Engineer A has a net worth of more than 50 million, which was way beyond his legitimate income. 2014. If you are the ombudsman, what charge or charges will you file against City Engineer A? If I'm the ombudsman, I would file a case of plunder under RA 7080 against City Engineer A. It is very clear from the facts given that all the elements of plunder are present, namely 1. The offender is a public officer holding a public office in the government of the Republic of the Philippines. B. The offender amassed, accumulated, or acquired ill-gotten wealth through a combination of overt or criminal acts, or misuse, misappropriation, conversion, or malversation of public funds, receiving kickbacks from persons in connection with a government contract or project by reason of his office or position, and illegally or fraudulently conveying or disposing of assets belonging to the national government or any of its subdivisions. And 3. The aggregate amount of total value of the ill-gotten wealth amassed, accumulated, or acquired is at least 50 million. Suppose that his covered net worth of city engineer is less than 50 million. Will your answer still be the same? Yes, the answer will still be the same, since in plunder, the basis is the combination of criminal acts or series of acts, which constitutes the accumulation of more than 50 million. The predicate crimes are already absorbed in the crime of plunder. City engineer's A's net worth being less than 50 million is not determinative of his liability as long as the wealth amassed, accumulated in is more than 50 million. Answer with brief explanations the following queries. If the slightest penetration of the female genitalia consummates rape by carnal knowledge, how does the accused commit attempted rape by carnal knowledge? D. Why is there no crime of frustrated serious physical injuries? 2017. Letter A. To be held liable for attempted rape by carnal knowledge, the penis of the accused must not touch the labia of the pendulum of the victim, but his acts must be committed with clear intention to have sexual intercourse. Intent to have sexual intercourse is present if it is shown that the erectile penis of the accused is in the position to penetrate. Cruz versus People, October 2014. Or the accused actually commenced to force his penis into the victim's sexual organ. People versus Banzuela, December 2013. If the offender touches the body of the victim through force, with lewd design but without clear intention to have sexual intercourse, the crime committed is acts of lasciviousness. People versus Sanico. Letter D. According to Justice Real Calado, the crime of physical injuries is a formal crime since a single act consummates it as a matter of law. Hence, it has no attempted or frustrated stage. Once the injuries are inflicted, the offense is consummated. 16-year-old Aliswan prodded Amethyst, his girlfriend, to remove her clothing while they were secretly together in her bedroom late one evening. Failing to get a positive response from her, he forcibly undressed her. Apprehensive about rousing the attention of the household, who did not know of his presence inside her room, she resisted him with minimal strength, but she was really sobbing in a muffled manner. He then undressed himself while blocking the door. Yet the image of a hapless and sobbing Amethyst soon brought him to his senses and impelled him to leave her room naked. He did not notice in his hurry that Amante, the father of Amethyst, who was then sitting alone on a sofa in the sala, saw him leave his daughter's room naked. Outside the house, the now-clothed Aliswan spotted Alesso, Amethyst's former suitor. Knowing how Alesso had aggressively pursued Amethyst, Aliswan fatally stabbed Alesso. Aliswan immediately went into hiding afterwards. Upon learning from Amethyst about what Aliswan had done to her, an enraged Amante wanted to teach Aliswan a lesson he would never forget. Amante set out the next day to look for Aliswan in his school. There Amante found a young man who looked very much alike Aliswan. Amante immediately rushed and knocked the young man unconscious on the pavement, then draped his body with a prepared tarpaulin, reading "Rapist ako, wag tularan." Everyone else in the school was shocked upon witnessing what had just transpired, unable to believe that the timid and quiet Aliswan's identical twin brother, had committed rape. A criminal complaint for attempted rape with homicide was brought against Aliswan in the prosecutor's office. However, after preliminary investigation, the investigating prosecutor recommended the filing of two separate informations, one for attempted rape and the other for homicide. Do you agree with the recommendation? Explain your answer. B. Before the trial court, Aliswan moved that the cases should be dismissed because he was entitled to the exempting circumstance of minority. Is this motion correct? C. After receiving medical attendance for 10 days, Alisto consulted you about filing the proper criminal complaint against Amante. What crimes, if any, will you charge Amante? D. Answering the criminal complaint filed by Alisto, Amante contended that he had incurred no criminal liability for lack of criminal intent on his part. His intended victim was Aliswan, not Alisto. What is the defense of Amante? 2017. Letter A. I do not agree with the recommendation of the filing of attempted rape. Intent to have sexual intercourse is an essential element of attempted rape. In other words, intent to lie with the victim must be closer. However, this intent is not established for failure to show that Aliswan had done acts to have sex with Amethyst, Cruz versus People, or that Aliswan had actually commenced to force his penis into the victim's sexual organ, People versus Valenzuela. Moreover, he spontaneously desisted from committing further lascivious acts after undressing Amethyst, which is a defense in attempted rape. Undressing the victim with lewd design merely constitutes acts of lasciviousness. However, I agree with the recommendation of separate charges instead of a special complex crime. Acts of lasciviousness cannot be merged with homicide. 2. For a special complex crime, there is no special complex crime of acts of lasciviousness with homicide under the statute books. Moreover, to be held liable of a special complex crime, there must be a direct connection between the components thereof. In this case, the homicide is not directly connected with the acts of lasciviousness, since the killing was motivated by a personal grudge of Aliswan against Alesso, which has no link to the crime committed against Amethyst. B. Since Aliswan's age is above 15 but below 18, being the brother of 16-year-old Aliswan, the exempting circumstance of minority shall be appreciated in his favor unless it is shown that he acted with discernment. The cases are not dismissible since the prosecution must be first given opportunity to present evidence to establish that Aliswan acted with discernment. Letter C. In People versus La Sala, which is similar to this case, the Supreme Court ruled that the crime committed is less serious physical injuries under Article 265 of the Revised Penal Code as the medical attendance is for a period of 10 days only. Considering, however, that the less serious physical injuries was inflicted with manifest intent to insult or offend the offended party or in their circumstances adding ignominy to the offense, there shall be an added penalty of fine not exceeding 500 pesos. Article 265. The defense raised by Amante is error in personae. This defense is not proper because of Article 4 of the Revised Penal Code, which provides that a person committing a felony is liable criminally, although the wrongful act done be different from the unlawful intent. Thus, under this provision, Amante is liable for the wrongful act done, and that is child abuse against Alisto, although it differs from the wrongful act intended, and that is abusing Aliswan. Jojo and Felipe are husband and wife. Believing that his work as a lawyer is sufficient to provide for the needs of their family, Jojo convinced Felipa to be a stay-home mom and care for their children. One day, Jojo arrived home earlier than usual and caught Felipa in the act of having sexual intercourse with their female nanny, Alma, in their matrimonial bed. In a fit of rage, Jojo retrieved his revolver from inside the bedroom cabinet and shot Alma, immediately killing her. A. Is Article 247 death of physical injuries inflicted under exceptional circumstances of the Revised Penal Code applicable in this case given that the paramour was of the same gender as the erring spouse? B. Is Philip liable for adultery for having sexual relations with Alma? 2016. Letter A. No. Article 247 of the Revised Penal Code is not applicable. Under the Revised Penal Code, for Article 247 to apply, the offender must catch his or her spouse in the act of committing sexual intercourse with another person. In People of the Philippines versus Marciano, the Supreme Court held that to avail of the privilege under Article 247, the accused should surprise his wife in the very act of sexual intercourse. Sexual intercourse generally presupposes the penetration of the man's sexual organ into that of a woman's. In this case, the paramour was the same gender as the erring spouse. As such, there is legally no sexual intercourse to speak of. Hence, Article 247 is not applicable. Alternative answer, yes. death or physical injuries inflicted under exceptional circumstances of the revised penal code is applicable. The requisites of Article 247 are legally married person surprises his spouse in the act of committing sexual intercourse with another person. He or she kills any or both of them or inflicts upon any or both of them any serious physical injury while in the act of immediately thereafter. And 3. He has not promoted or facilitated the prostitution of his wife, or that he or she has not consented to the infidelity of the other spouse. All the foregoing requisites are present in the case at hand. It is a given in the problem that Jojo caught Felipa and Alma in the act of sexual intercourse. The law did not qualify that the other person with whom the spouse be caught committing sexual intercourse be male or female. Hence, the gender of the paramour Alma, being of the same gender of the erring spouse Felipa, is immaterial. The answer given presupposes that Jojo and Felipa are legally married. Letter B. No, under Article 333 of the Revised Penal Code, adultery is committed by any married woman who shall have sexual intercourse with a man, not her husband. This Felipa having homosexual intercourse with Alma, a woman, is not committing adultery. A is the president of the corporate publisher of the daily tabloid BOOKll, B is the managing editor, and C is the author or writer. In his column, Direct Hit, C wrote about X, the head examiner of the BIR RDO Manila, as follows. Itong si X ay talagang buhaya, kaya ang logo ng Lacoste t-shirt niya ay napakaswapang na buhaya. Ang nickname niya ay si Attorney Buhaya. Ang PR niya ay 90% sa bayad ng taxpayer at ang para sa RP ay 10% lang. Kaya ang baba ng koleksyon ng RDO niya. Masyadong magnanakaw si X at dapat tanggalin itong bundat na buhay niya na ito at napalaki na ang kurakot. A, B, and C were charged with libel before the RTC of Manila. The 3 defendants argued that the article is within the ambit of qualified privilege communication, that there is no malice in law and in fact, and that defamatory comments on the acts of public officials which are related to the discharge of their official duties do not constitute libel. Was the crime of libel committed? If so, are A, B, and C liable for the crime? 2016. Yes, the crime of libel is committed. Fair comment on acts of public officers related to the discharge of their duties is a qualified privilege communication. Hence, the accused can still be held liable for libel if actual malice is shown. In fair comment, actual malice can be established by showing that comment was made with knowledge that it was false, or with reckless disregard of whether it was false or not. Gingging versus the Honorable Court of Appeals. Journalists bear the burden of writing responsibly when practicing their profession, even when writing about public figures or matters of public interest. The report made by C describing a lawyer in the Bureau of Customs as corrupt cannot be considered as fair and true, since he did not do research before making his allegations, and it has been shown that these allegations were baseless. The articles are not fair and true reports, but merely wild accusations. He has written and published the subject articles with reckless disregard of whether the same were false or not. Erwin Tulfer vs. People, 2008. A. President of the publishing company, B. Managing editor, and C. Writer of the defamatory articles are all liable for libel. Under Article 360 of the Revised Penal Code, the publisher and the editor of newspapers shall be responsible for the defamations contained therein to the same extent. The law makes the publisher and editor liable for libel as if they were the author. Tulfer vs. People. Broglio invited Lulu, his 11-year-old stepdaughter, inside the master bedroom. He pulled out a knife and threatened her with harm unless she submitted to his desires. He was touching her chest and sex organ when his wife caught him in the act. The prosecutor is unsure whether to charge Broglio for acts of lasciviousness under Article 336 of the RPC, for lascivious conduct under RA 7610, Special Protection Against Child Abuse, Exploitation and Discrimination Act, or for rape under Article 266-A of the RPC. What is the crime committed? 2016. The acts of Broglio of touching the chest and sex organ of Lulu who is under 12 years of age are merely acts of lasciviousness and not attempted rape, because intent to have sexual intercourse is not clearly shown. People versus Panzuela. To be held liable of attempted rape, it must be shown that the erectile penis of the accused is in the position to penetrate, or the offender actually commenced to force his penis into the victim's sexual organ. The same acts of touching the chest and sex organ of Lulu under psychological coercion or influence as her stepfather, Berlioz, constitutes sexual abuse under Section 5b of RA 7610. People versus Opiana. Since the requisites for acts of lasciviousness under Article 336 of the Revised Penal Code are met, in addition to the requisites of sexual abuse under Section 5 of RA 7610, and the victim is under 12 years of age, Berlioz shall be prosecuted for acts of lasciviousness under Revised Penal Code, but the penalty imposable is that prescribed by RA 7610. Employer versus People. Under Section 5, Number 6 of RA 7610, when the victim, child subjected to sexual abuse, is under 12 years of age, the perpetrators shall be prosecuted for acts of lasciviousness under Article 336 of the Revised Penal Code, provided that the penalty for lascivious conduct when the victim is under 12 years of age shall be reclusion temporal in its medium period. Lena worked as a housemaid and yaya of the 1-week-old son of the spouses John and Joanna. When Lena learned that her 70-year-old mother was seriously ill, she asked John for a cash advance of $20,000, but the latter refused. In anger, Lena gagged the mouth of the child with stockings, placed him in a box, sealed it with masking tape, and placed the box in the attic. Lena then left the house and asked her friend Feli to demand $20,000 ransom for the release of the spouse's child to be paid within 24 hours. The spouses did not pay the ransom. After a couple of days, John discovered the box in the attic with his child already dead. According to the autopsy report, the child died of asphyxiation barely minutes after the box was sealed. What crime or crimes did Linda and Feli commit? 2016. Lena is liable for murder, gagging the mouth of the child with stockings, placing him in a box, sealing it with masking tape, and placed the box in the attic, were only methods employed by the defendant in committing murder, qualified by the circumstance of treachery. People versus Laura. Taking advantage of the defenseless condition of the victim by reason of his tender age and killing him is treachery. People versus Falorina. She is not liable for kidnapping with murder, the essence of which is the actual confinement or restraint of the victim, or the deprivation of liberty. In this case, the victim was not deprived of liberty, since he immediately died. The demand for ransom did not convert the offense into kidnapping with murder. The defendant was well aware that the child would be suffocated to death in a few moments after she left. The demand for ransom is only a part of the diabolic scheme of the defendant to murder the child, to conceal his body, and then demand money before the discovery of the cadaver. People versus Laura. Feli is not liable for murder as principal or accomplice, since Feli did not participate in the actual killing of the child. She can only be held liable for murder as principal or accomplice on the basis of conspiracy or community of design. But in this case, there is neither conspiracy nor community of design to commit murder, since her criminal intention pertains to kidnapping for ransom. Moreover, her participation of demanding ransom for the release of the child is not connected to murder. Neither Feli is liable for kidnapping for ransom. Her criminal mind to assist Lena in committing kidnapping for ransom is not constitutive of a felony. Mens rea without actus reus is not a crime. What crime is committed by a person who kills a 3-day-old baby? Murder. What crime is committed by a person who kills his legitimate brother on the occasion of a public calamity? 2012. Murder. The key element in a crime of parricide, other than the fact of killing, is the relationship of the offender to the victim. Which one of the following circumstances constitute parricide? Offender killing his illegitimate mother. What crime is committed when a mother kills the 3-year-old child of her husband with their daughter, 2012. Murder. With intent to kill. GGG burned the house where F and D were staying. F and D died as a consequence. What is the proper charge against GGG, 2012? GGG should be charged with complex crime of double murder. At a wake, there were people watching a game of dice. With treachery and use of unlicensed firearms, AA fired successively several gunshots at their direction. During the shooting, 4 persons were killed and 14 others were injured and brought to the hospital for treatment of gunshot wounds. What should be the proper charge against AAA? 2012. AAA should be charged with 4 counts of murder and 14 counts of attempted murder. What crime is committed when a person ill-treats another by deed without causing an injury? The offender commits maltreatment. For treachery to qualify killing to murder, the evidence must show that the accused employed such means, methods, or manner to ensure his safety from the defensive or retaliatory acts of the victim, and the mode of attack was consciously adopted. FF and his 2 sons positioned themselves outside the house of the victim. The 2 sons stood by the stairs in front of the house, while the father waited at the back. The victim jumped out of the window and was met by FF, who instantly hacked him. The 2 sons joined hacking the victim to death. They voluntarily surrendered to the police. How will the attended circumstance be properly appreciated? Only treachery qualifies to killing to murder, because abuse of superior strength is absorbed by treachery. X killed B, mistakenly believing that she was his wife, upon surprising her having sex with another man in a motel room. What is the criminal liability of X? Homicide. Dagami concealed Bugna's body and the fact that he killed him by setting Bugna's house on fire. What crime or crimes did Dagami commit? Separate crimes of murder and arson, 2011. The accused was shocked to discover his wife and their driver sleeping in the master's bedroom. Outraged, the accused got his gun and killed both. Can the accused claim that he killed the 2 under exceptional circumstances? 2011. No, since the accused did not catch them while having sexual intercourse. On hearing a hospital ward patient on the next bed shrieking in pain and begging to die, Mona shut off the oxygen that was sustaining the patient, resulting in his death. What crime, if any, did Mona commit? 2011. Murder if she deliberated on her action. A criminal action for rape is extinguished when the offender is forgiven by 2011, the offender's wife, who herself is the rape victim. Explain and illustrate the stages of execution of the crime of homicide, taking into account the nature of the offense, the essential element of each of the stages of execution, and the manner of committing such intentional felony as distinguished from felony committed through reckless imprudence, 2012. Elements of the crime. Homicide as an intentional felony has 3 stages: attempted, frustrated, and consummated. In whatever stages homicide is committed, intent to kill must be established for being an indispensable element thereof. However, if the victim died as a consequence of wounds caused by an act committed with malice, intent to kill is conclusively presumed, and the crime committed is consummated homicide. Because of this conclusive presumption, lack of intent to kill is not a defense in consummated homicide. Note, in consummated homicide, the accused may prove lack of intent to kill for purpose of appreciating the mitigating circumstance of praeter intentionem. But if the victim did not die as a consequence of wounds caused by an act committed with malice, intent to kill must be established beyond reasonable doubt. If intent to kill is proven, the crime committed is frustrated or attempted homicide. If intent to kill is not proven, the crime committed is physical injuries. Thus, lack of intent to kill is a defense in attempted or frustrated homicide. Nature of the crime. If the offender with intent to kill attempted to inflict or inflicted non-mortal wounds upon the victim, he already directly commenced an overt act to commit homicide. Hence, the crime committed is attempted homicide. If he failed to inflict mortal wounds upon the victim by reason of some cause or accident other than his own spontaneous desistance, if the offender with intent to kill inflicted mortal wounds upon the victim, he already performed all acts of execution which would produce the homicide as a consequence. If that is not produced despite the mortal character of the wound, due to the causes independent of the will of the offender, the crime committed is frustrated homicide. If that is produced, the crime committed is consummated homicide. In this situation, all the elements necessary for execution and accomplishment of homicide are present if the victim dies due to the wounds inflicted by the offender with the intent to kill. Intentional felony and culpable felony. Homicide, regardless of stages, must be committed with malice, general intent, and intent to kill, specific intent. Even if there is no intent to kill and evil intent, the offender is liable for culpable felony if the victim dies or was injured as a result of the recklessness of the former. If there is no intent to kill, evil intent, and recklessness on the part of the accused, he is not liable for intentional act, which caused the death or injury upon the victim because of the exempting circumstance of accident. Macho married Ganda, a transgender. Macho was not then aware that Ganda was a transgender. On their first night after their marriage, Macho discovered that Ganda was a transgender. Macho confronted Ganda and heated argument ensued. In the course of the heated argument, a fight took place wherein Ganda got hold of a knife and stabbed Macho. Macho ran away from the stabbing thrust and got his gun with which he pointed at Ganda just to frighten and stop Ganda from continuing with the attack. Macho had no intention at all to kill Ganda. Unfamiliar with guns, Macho accidentally pulled the trigger and hit Ganda that caused the latter's death. What was the crime committed? 2014. Macho committed the crime of homicide. Since death resulted from Macho's act of accidentally pulling the trigger of the gun, homicide is committed. Here, intent to kill is a general criminal intent, which is presumed by law because the victim died. Out of spite and simply intending to put Gina to shame for breaking off with him, Richie emptied a gallon of motor oil on the school stairway, where Gina usually passed. Gina, unaware of what Richie did, used the slippery stairway and slipped, hitting her head on the stairs. Gina died from brain hemorrhage. What crime did Richie commit? Homicide. 2013. A. In a public place, fired his gun at B with the intention of killing B, but the gun did not fire because the bullet is a dud. The crime is attempted homicide. After a heated argument over his philandering, Higino punched on the head his wife, Aika, who was 6.5 months pregnant. Because of the impact, Aika lost her balance, fell on the floor with her head hitting a hard object. Aika died and the child was expelled prematurely. After 6 hours, the child died. 2015. What crimes did Higino commit? With respect to the killing of the wife, parricide under Article 246 of the Revised Penal Code is committed because of the qualifying circumstance of relationship. With respect to the killing of the child, Higino is liable for infanticide under Article 255 of the Revised Penal Code because his child was born alive and was already viable or capable of independent existence and the child's age is less than 3 days, for the latter died after 6 hours from expulsion. Higino shall incur criminal liability for parricide and infanticide, although these crimes committed are different from his criminal intention of maltreating his wife. Article 4 RPC. Inasmuch as a single act of Higino produced 2 grave felonies, it falls under Article 48, complex crime. Assuming that when the incident occurred, Aika was only 6 months pregnant, and when she died, the fetus inside her womb also died, will your answer be different? If the child died inside the womb of Aika, who was only 6 months, the crime committed is complex crime of parricide with unintentional abortion. Killing the unborn child as a result of the violence employed against the mother without intent to abort is unintentional abortion. Since the child died inside the womb of the mother, an intentional abortion is committed regardless of viability of the victim. Because the same violence that killed the mother also caused unintentional abortion, the crime committed is complex crime. People versus Pacaina. Honesto and Wilma were married but had been living separately due to irreconcilable differences. Honesto later met Celia and fell in love with her. Thinking that he could marry Celia if Wilma were to die, Honesto decided to kill Wilma. He secretly followed Wilma for weeks to learn her daily routine. He decided to kill her at night on her way home. On the night he was to kill Wilma, Honesto wore dark clothes so that he would not be easily seen. He waited in the dark alley for Wilma to pass by. He saw someone whom he thought looked like Wilma and shot her with a revolver. The bullet passed through the person's head and grazed another passerby's arm. Some bystanders who heard the shot were able to stop Honesto. It turned out that Wilma did not report for work on that day, and the one who was shot in the head was Melba, who died. The passerby whose arm was grazed by the bullet required medical attendance for 2 days. 2015. What crimes did Honesto commit? Explain. Honesto is liable for murder, qualified by the circumstance of treachery for killing Melba due to error in personae or mistake of identity, and slight physical injuries for the wound sustained by the passerby due to aberratio ictus or mistake of blow. Although his intention to commit parricide, he is liable for murder and slight physical injuries since they are the direct, natural, and logical consequence of act committed with intent to kill his wife. Will your answer be the same, assuming that the other passerby was hit in the left eye, which caused her or his blindness? If the passerby was hit in the left eye, causing blindness, the crime committed by Honesto is serious physical injuries. Unlike slight physical injuries, serious physical injuries can be made a component of a complex crime under Article 48 of the Revised Penal Code. Since a single act of shooting the victim constitutes murder and serious physical injuries, they can be merged together to form a complex crime. Thus, my answer would be different since the crime would be murder with serious physical injuries. Leto, a minor, was bullied by Brutus, his classmate. Having had enough, Leto got the key to the safe where his father kept his licensed pistol and took the weapon. Knowing that Brutus usually hung out at a nearby abandoned building after class, Leto went ahead and hid while waiting for Brutus. When Leto was convinced that Brutus was alone, he shot Brutus, who died on the spot. Leto then hid the gun in one of the empty containers. At the time of the shooting, Leto was 15 years old, 1 month old. What is Leto's criminal liability? 2015. Leto is criminally liable for murder qualified by the circumstance of treachery or evident premeditation as well as illegal possession of firearms. Minority is not an exempting under Section 7 of RA 9644. Since his age is above 15 years, but below 18 years, and he acted with discernment. Circumstance will show that he discerned the consequences of his criminal acts as shown from the fact he employed means to make a surprise attack, and he even hid the murder weapon in an empty container. It was also clear that he planned the killing. However, minority will be considered as a privileged mitigating circumstance, which will require the graduation of the penalty prescribed by law to 1 degree lower, Article 68. Choose the correct circumstance when woman may be held liable for rape, 2013. When she befriends and puts a sleeping pill in the victim's drink to enable her husband to have intercourse with the victim. If Rod killed Irene, his illegitimate daughter, after taking her diamond earrings and forcing her to have sex with him, what crimes should Rod be charged with, 2013? Rape with homicide. Charlie was charged for the qualified rape of AAA. The information alleged that AAA was 14 years at the time the crime was committed and that Charlie was AAA's stepfather. The presentation of AAA's birth certificate during the trial duly established the following: that AAA was indeed 14 years of age at the time of the rape, and that AAA's mother is Triple B, and her father was the late Triple C. Triple B and Charlie only became live-in partners after Triple C's death. The RTC found Charlie guilty of qualified rape. On appeal, the Court of Appeals convicted Charlie of simple rape. Charlie appealed before the Supreme Court. How will you rule and why? 2015. The CA ruling is correct. The crime committed by Charlie is simple rape. To be held liable for qualified rape, a qualifying circumstance should be alleged in the information and proven by evidence beyond reasonable doubt. Although minority and step relationship as a qualifying circumstance are alleged in the information, what is proven by the evidence is the qualifying circumstance of minority and common law relationship with the mother of the victim. The concept of step relationship is different from that of common law relationship because in the former, the mother of the victim and the offender are legally married, while in the latter, they are not. To appreciate this qualifying circumstance of minority and common law relationship will offend the constitutional right of the accused to be informed of the nature of the crime charged against him. Procopio, a call center agent assigned at a graveyard shift, went home earlier than usual. He proceeded immediately to their bedroom to change his clothes. To his surprise, he found his wife, Beyoncé, in bed making love to another woman, Magna. Enraged, Procopio grabbed a knife nearby and stabbed Beyoncé, who died. 2015. What crime did Procopio commit and what circumstance attended the case. The crime committed by Procopio is parricide, qualified by the circumstance of relationship. Killing a spouse after having been surprised in the act of committing sexual intercourse with another woman is death, under exceptional circumstances under Article 247 of the Revised Penal Code. However, in this case, this is not death under exceptional circumstance because Beyonce was having homosexual intercourse with another woman and not sexual intercourse with a man. Homosexual intercourse is not within the contemplation of the term sexual intercourse in Article 247. However, the crime of parricide is attended by the circumstance of passion arising from a lawful sentiment as a result of having caught his wife in the act of infidelity with another woman. People versus Bellarmino. Assuming that Procopio and Beyonce were common law spouses, will your answer be the same? No, the answer is not the same. The crime committed is homicide if Procopio and Beyonce were common law spouses. Parricide contemplates killing by a spouse who are legally married. What is the criminal liability, if any, of a pregnant woman who tried to commit suicide by poison but she did not die and the fetus in his womb was expelled instead? 2012. The woman who tried to commit suicide incurs no criminal liability for the result not intended. A, B, and C are members of SFC fraternity. While eating in a seaside restaurant, they were attacked by XYZ and Z, members of a rival fraternity. A rumble ensued in which the above-named members of the two fraternities assaulted each other in a confused and tumultuous manner, resulting in the death of A. As it cannot be ascertained who actually killed A, the members of the two fraternities who took part in the rumble were charged for death caused in a tumultuous affray. Will the charge prosper? 2010. No, the charge of death caused in a tumultuous affray will not prosper. In death caused by tumultuous affray under Article 251 of the Revised Penal Code, it is essential that the person involved did not compose groups organized for the common purpose of assaulting and attacking each other reciprocally. In this case, there is no tumultuous affray since the participants in the rumble belong to organized fraternities. The killer of A member of SFC fraternity, could not be any other but member of the rival fraternity. Conspiracy is therefore present among the attackers from the rival fraternity and thus rules out the idea of an affray. The liability of the attackers should be collective for the crime of homicide or murder as the case may be. Mr. P owns a boarding house where he knowingly allowed children to be videotaped while simulating explicit sexual activities. What is Mr. P's criminal liability? 2011. Violation of the Child Pornography Act. Tonito, an 8-year-old boy, was watching a free concert at the Luneta Park with his father Tony. The child stood on a chair to be able to see the performance on the stage. Juanito, a 10-year-old boy who was also watching the concert, could not see much of the performance on the stage because Tonito was blocking his line of sight by standing on the chair. Using his elbow, Juanito strongly shoved Tonito to get a good view of the stage. The shove caused Tonito to fall to the ground. Seeing this, Tony struck Juanito on the head with his hand and caused the boy to fall and to hit his head on the chair. Tony also wanted to strangle Juanito, but the latter's aunt prevented him from doing so. Juanito sustained a lacerated wound on the head that required medical attendance for 10 days. Tony was charged with child abuse in violation of Section 10, letter A, in relation to Section 3, letter B, number 2 of RA 7610, Child Abuse Law, for allegedly doing an act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. In his defense, Tony contended that he had no intention to maltreat Juanito, much less to degrade his intrinsic worth and dignity as a human being. Distinguished crimes mala inse from crimes mala prohibita. Was Tony criminal liable for child abuse under RA 7610? Explain your answer. Tony laid hands on Juanito without intent to debase the intrinsic worth and dignity of Juanito as a human being, or that he had thereby intended to humiliate or embarrass Juanito. It appears that the laying of hands on Juanito, having been done at the spur of the moment and in anger, indicative of his being then overwhelmed by his fatherly concern for the personal safety of his own minor son, Tonito, who fell to the ground due to the shoving by Juanito. With the loss of his self-control, he lacked that specific intent to debase, degrade, or demean the intrinsic worth and dignity of a child as a human being that was so essential in the crime of child abuse. Hence, the crime committed is only slight physical injuries. BOOKll versus People. Arnold, 25 years of age, was sitting on a bench in Luneta Park watching the statue of Jose Rizal, when without his permission, Leilani, 17 years of age, sat beside him and asked for financial assistance, allegedly for payment of her tuition fee, in exchange for sex. While they were conversing, police operatives arrested and charged him with violation of Section 10 of RA 7610, Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act, accusing him of having in his company a minor who is not related to him, in a public place. It was established that Arnold was not in the performance of social, moral, and legal duty at that time. Is Arnold liable for the charge? 2016. No, Arnold is not liable under Section 10 of RA 7610, and a person who shall keep or have in his company a minor 12 years or under, or who is 10 years or more his junior, in any public or private place, hotel, motel, beer joint, discotheque, cabaret, pension house, sauna or massage parlor, beach and or other tourist resort or similar places liable for child abuse. Arnold is not liable for the charge. To be held liable under Section 10, Number 6 of RA 7610, it is indispensable that the child in the company of the offender must be 12 years or under, or who is 10 years or more his junior in a public place. In this case, Leilani is 17 years of age and only 8 years younger than Arnold. Moreover, Leilani sat beside Arnold without his permission, hence he is not in the company of a child in a public place. Lastly, applying the adjustem generis principle, Arnold is not liable for child abuse because Luneta is not a place similar to hotel, motel, beer joint, discotheque, cabaret, pension house, sauna or massage parlor, beach and or other tourist resort. Angelino, a Filipino, is a transgender who underwent gender reassignment and had implants in different parts of her body. She changed her name to Angelina and was a finalist in the Miss Gay International. She came back to the Philippines, and while she was walking outside her home, she was abducted by Max and Rossi, who took her to a house in the province. She was then placed in a room and Rossi forced her to have sex with him at knife point. After the act, it dawned upon Rossi that Angelina is actually a male. Incensed, Rossi called Max to help him beat Angelina. The beatings that Angelina received eventually caused her death. What crime or crimes, if any, were committed? 2016. Rossi is liable for kidnapping with homicide. Abducting Angelino is not forcible abduction, since the victim in this crime must be a woman. Gender reassignment will not make him a woman within the meaning of Article 342 of the Revised Penal Code. There is no showing, moreover, that at the time abduction is committed with lewd design. Hence, his abduction constitutes illegal detention. Since Angelino was killed in the course of the detention, the crime constitutes kidnapping and serious illegal detention with homicide under Article 267. Having sexual intercourse with Angelino is not rape through sexual intercourse, since the victim in this case must be a woman. This act is not rape through sexual assault. Either Rossi did not insert his penis into the anal orifice or mouth of Angelino, or an instrument or object into anal orifice or genital orifice. Hence, this act constitutes acts of lasciviousness under Article 336. Since the acts of lasciviousness is committed by reason or occasion of kidnapping, it will be integrated into one and indivisible felony of kidnapping with homicide. People versus De Leon. Max is liable for kidnapping with homicide as an accomplice, since he concurred in the criminal design of Rossi in depriving Angelino his liberty and supplied the former material aid in an efficacious way by helping him beat the latter. What is the crime committed by any person who, without reasonable ground, arrests or detains another by the purpose of delivering him to the proper authorities? 2012. Unlawful arrest. Which among the following circumstances do not qualify the crime of kidnapping? The offender is a public officer. The three accused forcibly took their victim from his car, but the latter succeeded in freeing himself from their grip. What crime did the three accused commit? Grave coercion. A entered the house of B. Once inside the house of B, A took and seized personal property by compulsion from B, with the use of violence and force upon things, believing himself to be the owner of the personal property so seized. What is the criminal liability of A? 2012. A is criminal liable for grave coercion because the presumption of intent to gain is rebutted. AA was arrested for committing a bailable offense and detained in solitary confinement. He was able to post bail after 2 weeks of detention. During the period of detention, he was not given any food. Such deprivation caused him physically discomfort. What crime, if any, was committed in connection with the solitary confinement and food deprivation of AA? 2012. The crime of torture and maltreatment of prisoner is committed. Food deprivation and confinement in solitary cell are considered as physical and psychological torture under Section 4, Number 2 of Anti-Torture Act of 2009. Torture refers to an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or her or a third person information or a confession punishing him or her for an act which he or she or a third person has committed or is suspected of having committed, or intimidating or coercing him or her or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent of acquiescence of a person in authority or agent of a person in authority. RA 9745 Section 3. Pretty was a campus beauty queen who, because of her looks and charms, attracted many suitors. Having decided that she would become a nun, Pretty turned down all her suitors. Guapo, one of her most persistent suitors, could not handle rejection and one night decided to accost Pretty as she walked home. Together with Pogi, Guapo forced Pretty into his car and drove her to an abandoned warehouse, where he and Pogi forced Pretty to dance for them. Later, the two took turns in raping her. After satisfying their lust, Guapo and Pogi dropped her off at her house. 2014. What crime or crimes did Guapo and Pogi commit? The crimes committed by Guapo and Pogi are forcible abduction with rape. There is no doubt at all that the forcible abduction of Pretty as she walked home was a necessary, if not indispensable, means which enabled them to commit the successive acts of rape upon her person. It bears noting, however, that even while the first act of rape was being performed, the crime of forcible abduction had already been consummated. For that, the second rape cannot legally be considered as still connected with the abduction. In other words, the second rape would be detached from and considered independently of that of forcible abduction, and therefore the former can no longer be complex with the latter. People versus Jose. Since there is conspiracy, Guapo and Pogi are responsible not only for the rape each personally committed, but also for the rape committed by his co-conspirator. People versus Villa. Pretty, after the ordeal, decided to take her own life by hanging herself 1 hour after the rape. Would Guapo and Pogi be liable for Pretty's death? Guapo and Pogi cannot be held liable for the death of Pretty due to suicide committed by reason of the rapes. Suicide is an intervening cause that breaks the connection between the rapes and death. The death resulting from suicide cannot be considered as a direct, natural, and logical consequence of the rapes committed by Guapo and Pogi. In People versus Napudo, the victim committed suicide due to rape. However, the accused was only charged with and convicted of rape. Sexy boarded a taxi on her way home from a party. Because she was already tipsy, she fell asleep. Pogi, the taxi driver, decided to take advantage of the situation and drove Sexy to a deserted place where he raped her for a period of 2 weeks. What crime did Pogi commit? 2014. The crime committed by Pogi is kidnapping and serious illegal detention with rape. Since Sexy was raped for 2 weeks, there was a clear deprivation of liberty, which constitutes the crime of kidnapping with serious illegal detention. The crime is committed when one kidnaps or detains another, or in any other manner deprives her of her liberty, and the kidnapping or detention has lasted more than 3 days, or the victim is a female. Since, as a consequence of the detention, the victim is raped, the crime committed is special complex crime of kidnapping with rape. The resultant crime is only one kidnapping with rape. This is because the composite acts are regarded as a single indivisible offense, as in fact, RA 7659 punishes these acts with only one single penalty. People versus Mirandilla. While walking alone on her way home from a party, Mildred was seized at gunpoint by Felipe and taken on board a tricycle to a house some distance away. Felipe was with Julio, Roldan, and Lucio, who drove the tricycle. At the house, Felipe, Julio, and Roldan succeeded in having sexual intercourse with Mildred against her will and under the threat of Felipe's gun. Lucio was not around when the sexual assault took place as he left after bringing his colleagues and Mildred to their destination, but he returned every day to bring food and the news in town about Mildred's disappearance. For 5 days, Felipe, Julio, and Roldan kept Mildred in the house and took turns in sexually assaulting her. On the 6th day, Mildred managed to escape. She proceeded immediately to the nearest police station and narrated her ordeal. What crimes did Felipe, Julio, Roldan, and Lucio commit, and what was their degree of participation? 2013. Felipe, Julio, Roldan, and Lucio are all liable of the special complex crime of kidnapping and serious illegal detention with rape. It was sufficiently proved that the four kidnapped Mildred and held her in detention for 5 days and carnally abused her. Notably, however, no matter how many rapes have been committed in the special complex crime of kidnapping with rape, the resultant crime is only one kidnapping with rape. The composite acts are regarded as a single indivisible offense with only one penalty. The offense is not forcible abduction with rape, since it's what obvious that the intent is to detain the victim. As to the degree of their participation, all of them are principally liable because of implied conspiracy as they acted toward a single criminal design or purpose. People versus Miranda. Albeit Lucio was not around when the sexual assault took place, his complexity is evident as he was the one who drove the tricycle and returned every day to bring food and news to his cohorts. At the Maligaya Disco Club, Leonce and Evelyn were intimately dancing a very seductive dance number. While gyrating with their buddies, Leonzo dipped his private parts in Evelyn's buttocks. Incensed? Evelyn protested, but Leonzo continued and tightly embraced her. What crime or crimes, if any, did Leonzo commit? 2009. Leonzo committed the crime of unjust vexation only because the act was done in the course of dancing. The act of dipping his private parts in Evelyn's buttocks during a very seductive dance, although offensive to Evelyn, may be viewed as part of the dirty dancing. Lewd intent cannot simply be presumed from the act of dirty dancing. The fact that the act was perpetrated in a public place and with an audience negates lewd designs or lascivious intent, which is essential in the crime of acts of lasciviousness. Virgilio, armed with a gun, stopped a van along a major thoroughfare in Manila, pointed the gun at the driver and shouted, "Tigil, kidnapito." Terrified, the driver, Juanita, stopped the van and allowed Virgilio to board. Inside the van were Jeremias, a 6-year-old child, son of a multimillionaire, and Daday, the child's nanny. Virgilio told Juanita to drive to a deserted place, and there ordered the driver to alight. Before Juanita was allowed to go, Virgilio instructed him to tell Jeremiah's parents that unless they give a ransom of 10 million within 2 days, Jeremias would be beheaded. Daday was told to remain in the van and take care of Jeremias until the ransom is paid. Virgilio then drove the van to his safe house. What crime or crimes, if any, did Virgilio commit? The crime committed against Jeremias, the 6-year-old child, is kidnapping and serious illegal detention under Article 267. Number 4. RPC. The evident criminal intent of the offender Virgilio is to lock up the child to demand ransom. Whether or not the ransom was eventually obtained will not affect the crime committed because the demand for ransom is not an element of the crime. It only qualifies the penalty to death, but the imposition of this penalty is now prohibited. As to Daday, the nanny of the child, who was told to remain in the van and take care of the child until the ransom is paid, the crime committed is serious illegal detention because the offended party deprived of liberty is a female. Article 267, paragraph 4. As to Juanito, the driver of the van, who was seriously intimidated with a gun pointed at him and directed to stop the van and allow the gunman to board the same, and thereafter to drive to a deserted place, the crime committed by Virgilio is grave coercion. Article 286, and slight physical illegal detention for holding the driver before he was allowed to go. True or false? The creditor who resorts to forced labor of a child under the pretext of reimbursing himself for the debt incurred by the child's father commits the crime of slavery. False. The proper offense is exploitation of child labor, Article 273. Exploitation of child labor is committed by a person who, under the pretext of reimbursing himself of a debt incurred by an ascendant, guardian, or person entrusted with the custody of a minor, shall against the minor's will retain him in his services. A waiter of 10 years, septa octogenarian Canuto felt that he had license to engage in voyeurism, if not peeping into his neighbors' rooms through his powerful single-cylinder telescope. He would trail young, shapely damsels along the hallway of shopping malls. While going up the escalator, he stayed a step behind a mini-skirted one, and in a moment of excitement put his hand on his left hip and massaged it. The damsel screamed and hollered for help. Canuto was apprehended and brought up on inquest. What charge, if any, may he be held responsible for? 2010. Canuto may be held liable for the milder crime of unjust vexation, which is a form of a slight coercion under Article 287 of the Revised Penal Code, instead of the crime of acts of lasciviousness, although the offender is known for his voyeurism. Our Revised Penal Code inclines towards milder criminal responsibility, consistent with the presumption of innocence and under our fundamental law and the rule of pro reo, permitting our system of applying penal laws. Holding the hip of a person is not per se lascivious, but undoubtedly annoys, irritates, and vexes the young offended party. The attitude to prosecute the offender for the milder crime of unjust vexation may be proper, considering his age and civil status. A was caught peeping through a small hole in the bathroom door while a young 16-year-old lady was taking a bath. A is liable for light coercion. 2014. From an extension line, Ricardo overheard a telephone conversation between Julito and Attorney Hippolito. The latter, Attorney Hippolito, was asking money from Julito in exchange for dropping the extortion charge filed against Julito. Ricardo was charged of violating Anti-Wiretapping Act of RA 4200. Under these facts, was there a violation as charged? No, because the telephone extension line is not the device or arrangement contemplated by the law, and the use of an extension line cannot be considered as wiretapping.